Yes, ladies and gentlemen, welcome all. This is the aquarium, and this is my micro, and the title of this panel has to do with elephants. So it's an interesting metaphor to have elephants in an aquarium, but that's... I would suggest, for my peace of mind, that we rather have the image of fish in an aquarium in our head, so to move and navigate intelligently into a very controlled setting, and I think that's what the EDPB is doing. And so the fish in the aquarium today is the EDPB, a mystical organ that has been created by the GDPR. And we don't know who those people are. At least, usually, it's like the Interpol. Interpol exists, but you never shake hands with an agent or an officer from Interpol. So it's secret. So welcome. This is a panel that has the advantage of following up on the bigger panel, and a lot of issues that are on the panel's agenda now have been touched upon before in the bigger hall. But it's good to have some of these issues return and have other people, sometimes people with a brand and a trust factor that is very high, and to listen to those people about these issues. And I think that's how it goes. There is not one authority in this debate. There are many. And I think just allowing certain issues to circulate is the way ahead. So today we have, first of all, we have an excellent panel. Thank you. And how is this panel conceived? First of all, we have Gwendal Legrand, who is responsible for enforcement at the EDPB. And so he's the Interpol person of today, voicing Europe. And then we have also from the institutional side, Florence Raynal, who is Deputy Director for the International European Affairs at the CNIL, voicing the local, but we can hardly call the CNIL local because it resonates outside France, of course, whatever they do. And then we have a board of wise people. And first we have Bojana Bellamy, who is a specialist in European law issues and thinking through European elephants and fish. And she's currently the president at the CIPO, which is the Center for Information Policy. I try to read all their reports, and they always are of excellent quality, and they dare to open debates where academics tend to study debates, rather. So very happy to have somebody who's going to make us think, rather than reproducing people that think in the panel. And then we have Estelle Massé, who is working at Access Now. And Estelle, you are the European Legislative Manager and Global Data Protection Lead. We had a Fanny for Access Now in the other panel, insisting on a bottom-up approach with regard to enforcement, listening to the people, putting the subject first. That was an interesting debate, because most of us are, of course, thinking Brussels-wise, top-down, and so on. So I think the presence of Access Now in whatever panel today is a needed one. And Estelle, thank you for joining us. So without losing too much time, we're going to finish in exactly 1 hour, and there is a Q&A session at the end. And there will be the Zuboff speech today, teaching us about the ins and the outs of data capitalism, and we're all entrapped in that system, so we have to listen, because there might be a way to enlightenment and a way to alter these things. But let's now concentrate on the theme of today. So there is, in the GDPR, there are sections on cooperation and the one-stop shop. And the one-stop shop, of course, starts with cooperation. And when it goes bad, or when it, under certain circumstances, the one-stop shop procedures might go to the EDPB. And then there is a conflict resolution system in the GDPR. All that is clear to you. But today we want to cut the cake appropriately. And first we want to hear from Florence and then from Gwendal, how they see this one-stop shop cooperation mechanism between DPAs when things go well, when the EDP, when the elephant is not there yet, It's a big animal. We know the animal is somewhere around there. But when things go well, the elephant can stay out of this fishbowl. Florence, how is this cooperation between DPAs evolving? And also, because it's some years old, what are the DPAs themselves doing, and where are they innovating the procedures or trying to bend certain rules in a way that makes cooperation more feasible?
Thank you very much, Paul. If you allow me, maybe I will share with you the lessons that we learn from the beginning of the GDPR, so since 2018. And one of the lessons that we learn is that the GDPR provides for a unique enforcement model of cooperation in the world. It is the most integrated and the most advanced model of collaboration between supervisory authorities that exist today. And we tend to forget a little bit about it, but in fact we are building something that is really new and that does not exist anywhere else in the world. Before, under the directive, we were meeting in Brussels 5 times a year to adopt guidelines and tools, which was already a lot, but it was not enough. With the GDPR, it's about taking binding decisions on concrete cases and concrete actors all together. It's not only about interpreting in a coordinated way, it's about enforcing the rules in real and together. Since May 2018, we have cooperated on around 2,000 concrete cases, with cumulative fines amounting to €1,055,000,000. Internally, I can tell you that it has had a significant impact on the way we are organized at the CNIL. We have put in place dedicated teams with IT and legal experts. We have special meetings every week to coordinate the different divisions internally. We have special arbitration meetings every week with our president and our general secretaries on cross-border cases. We have also many exchanges with our counterparts on a daily basis. It means in practice hours of meetings, virtually, by phone or physically. We are also organizing collaborative, coordinated action, such as with our Dutch or Luxembourg colleagues. And this cross-border case, and on this cross-border case, we are not talking only about big fish. We are also talking about smaller cases involving smaller companies, SMEs, and still the issues are significant. We are talking about geolocation or protection of children. So it's not only about big companies. And the variety of subjects we are dealing with is very, very large. It's about the gravity of an infringement. It's about the international character of the infringement, the level of fine, or again the legal or else the legal basis applying to a very specific processing. So it's very complex matter that we are dealing with every day with our counterparts. And this is new. This is new. It was not the case before the GDPR. It's a total new way to collaborate between supervisory authority. Today, we are collaborating on a daily basis on concrete complaints that are coming from anyone in Europe and concerning any actor targeting the EU market. And to succeed, we have to familiarize ourselves with different ways of enforcing data protection, with different cultures, with different legal backgrounds of the 27 member states. This is a GDPR revolution. That is why it's complicated for DPA to do, and the reason why it takes time. Just like Rome was not built in a day, it takes time to move from various practices to a common one. We are really building an EU enforcement data protection culture. Another lesson is that it costs money. We all need sufficient resources to carry out our duties. And this is an important factor to take into consideration because we cannot necessarily meet all the expectations. I have this image from my Dutch colleague saying that it's like filling in a car with half of gas and wondering why it stopped in the middle of the road. Also, it's worth to underline that cross-border case represent just a small part of the complaints we receive. Approximately 80%, 85% of the complaints we are dealing with are national and concerning national actors. But we agree, it's not perfect. And we are aware of it. And we need to improve the system. So, in a nutshell, what are the hurdles? We need to make the system quicker and more efficient. We need to have quick decisions on strategic cases. We need to find practical solutions to manage minor cases in an efficient way. We need, as Didier Render said, tools to better cooperate, to have a better coordination. We need to make the GDPR enforcement tools easy to use. And finally, we need to harmonize national procedure.
Okay.
If you allow me, Paul, I will come back in the second round about solutions that we have already think about with the EDPB and also at local level. Thank you.
So a lot of cases, it's new, it's revolution, and it takes time and money to make it work. And that is, but there are solutions and issues that around, and there's a reflection on it. I want to have your view both on the efficiency of the cooperation procedure in this stage, but also what can be done to enhance trust and what can be done to address some of these issues without immediately calling for GDPR reform. Gwendal.
Okay, thank you, and thank you for the invitation. So we've talked a lot about the OSS, but you know that under the OSS, of course, when there's a cross-border case, authorities are working together, they try to reach a consensus. It doesn't happen all the time, and when there's no consensus, the EDPB kicks in and solves the dispute, and has to do this in a very short time, has to be very fast, and it has to meet high-quality standards. Now, we've heard a lot about the OSS this morning, and it reminded me of the Olympic motto, you know, faster, higher, stronger, together. This is basically what we've been saying since this morning. And when you talk about sports, you talk about performance. So what do we have in terms of results so far at the EDPB level? We've worked on a high number of cases under the OSS. And there's more than 2,000 cases on which there is cross-border cooperation. There's been more than 1,000 cases on which there is the OSS that was triggered. And there's more than 380 decisions that were taken so far. And as Florence said, the fines are also increasing. So last year was 1.3 billion of fines. The total is 1.5. So last year was 5.5 times more than in all the history of GDPR. So this is ramping up at national level, and we also see it at the European level at EDPB. If we take the image of sports, we also try to improve all the time. So what do we do at EDPB level to try to improve the performance? There's been a number of initiatives that have been done so far. There's task forces on important cases. In October last year, we did the coordinated enforcement framework. Perhaps I'll say more about this in the second round. It's, you know, you choose the topic, you prioritize this topic. This year is cloud in the public sector, and the authorities are working together to have a common approach to enforcement. And they do it in a synchronized way, they do it on a common topic, and basically the objective is threefold: sharing experience, sharing the workload, and leveraging on the results you obtain at national level to make sure it's applied everywhere. Another initiative is the SPE, the support pool of experts. So we've mentioned this a couple of times. The idea is to pool expertise between the authorities, and we also did a call for external experts that can be used to help the authorities on enforcement-related matters. So it's about building tools, and sharing experience and making this experience available so that we're more efficient together. And then there was this meeting in Vienna. So the cooperation is happening at the technical level of the experts and the authorities. It's also happening at the political level. And this Vienna meeting that you've been hearing about so much since this morning, it was a meeting of the commissioners, of the heads of authorities during 2 days at the end of April to decide how to better work together. And they issued this statement, and in the statement, there's a lot of ideas that we find in there that we're trying to follow up on, but I will highlight 3 things very briefly. The first one is the strategic cases. So identifying cases of importance across the EU on which close cooperation is going to be implemented by small groups of DPAs, sharing the workload to be faster, higher, stronger together, basically. The second thing is each authority is working at national level and they have enforcement strategies. You know, they prioritize a certain number of topics for in their investigations for the following year. Here again, you can share experience to be more impactful together by not acting in silos, but sharing the priorities, deciding the priorities at EDPB level, and deciding how to approach a topic at EDPB level. So these are the national enforcement priorities in a way that are going to be Europeanized. And the last thing is these procedural issues. So again, you've heard a lot about this. What we have done concretely at EDPB level is ask for some input from all the national authorities to identify, based on their 4 years of experience, what can be further improved, what can be harmonized in EU law. And without preempting anything from the input from the authorities, you've heard already some topics, like whether or not the plaintiff is party to the procedures, things related to delays, access to documents, and so on and so forth, that can be perhaps harmonized and facilitate this working together between the authorities. So it works. We're doing a lot, and like the athletes, we're trying to constantly improve to make it even more efficient.
Wow, thank you. Bojana, help me. I want to be critical, but I don't know how. It looks all brilliant. There's something new, and the right people are doing it, and there's a learning process, and they're transparent about it. I mean, at my university, we would hire those people. But Bojana, what does this to you? Are you charmed? Are you no. Sweetened by?
I did not plan to start like that. Okay, but look, first of all, why are we here? I mean, great kudos for Wojciech and EDPS and EDPB team to actually have organized this conference, because there is an elephant in the room. Something is not working, and we want to make it better. Today, Anu, who was on the panel, said, you have to be only friends and supporters of GDPR should be criticizing GDPR. And I think that's what we're trying to do. So we here are friends, supporters. My husband often says you only joke with people who you love. So that's why, please take these comments in that spirit. And the comments are the following. Yes, it's not working perfectly, but one-stop shop is the innovative tool of GDPR, and it's the cornerstone of GDPR. It is absolutely necessary to ensure the unified single European market, not only for companies, but for people. I'm not in EU anymore because I live in London, unfortunately, so I'm waiting for Serbia to join, then I'll be back into EU. So, but individuals have to have the same level of protection and same legal certainty, just like companies have to have one-stop shop. So one-stop shop is here to stay, and we must do whatever it takes to make it better. Somebody in UK, one of the prime ministers said, we don't have a reverse gear. I don't think we do not have a reverse gear, and we've heard from the Commissioner Reinders, we do not have a gear to change drastically the rules of one-stop shop, so it must work. I do want to remind, and this shows how old I am, but Florence, we were working together, and Gwendal, I think for a long time. I was the head of privacy at a big European-based multinational company, and we were talking about one-stop shop, but not from the perspective of enforcement, but from the perspective of actually having a one-stop shop to deal with everything, right? For cooperation, for joint thinking. And I do remember conversations with Vivian Redding then. What was this supposed to look like, right? We were supposed to just take away the burden, the administrative burden, but to work on everything together so that we've got that kind of unified point of view. And I think that is what I remember very well. And then, of course, it was kind of watered down from that initial view. And we remember why proximity, we'll talk about that as well. And now we've got this system, which Orla Linsky says is sort of by design unequal. And it's true, it is by design unequal, but we have to make it work unless we change completely the system. And it doesn't look like we will change. So some of the things that, and by the way, we have actually written a paper, as you have heard, we write lots of papers, but September 2021 on some of the sort of hard facts on one-stop shop, but also very solution-oriented. And I think one of the things I would like to see is kind of going back to what this was going to be about. One-stop shop is about having a common understanding, shared knowledge, cooperation, as opposed to just enforcement, right? This isn't just about enforcement cooperation, it's about a cooperation so that we never get to enforcement, and cooperation so that when we get to enforcement, we have a shared views of how things are. And so I do really want to remind, I mean, look at Article 61, mutual assistance. It's about sharing information, it's about effective cooperation on cases about information requests, supervision measures, prior authorizations, consultations. There's no enforcement in that article until later. And so what I think is essential is to remember, in order to deal with the difficult cases of enforcement in a shared way, we have to build shared way of thinking and cooperating on basics. Article 64 tells us the board opinions are there to help us, on DPIA list, on codes of conduct, certifications, SCCs, BCRs, authorized ad hocs. So that's the way you cooperate. That's the way you learn joint language of data protection supervision in Europe. So I would like us to think more about front-loading this whole topic to cooperation, joint sharing, joint understanding of each other before we then start how do we go into enforcement. And in fact, we have proposed kind of also some of the maybe sort of best memorandum of understanding or perhaps code by which DPAs do that, and which is mutual respect, administrative autonomy, and self-restraint. And I think we do need to have that as well as that shared point of view. Shared point of view means also setting shared priorities. And I would like, and I've seen that now with Vienna, I want to say Vienna Convention, right? We remember the Vienna Convention, but the Vienna...
Declaration.
Declaration.
Statement.
Okay, perfect. So everything important happens in Vienna. So yes, with Vienna Declaration, we've seen that progress where there is that sharing of regulatory approaches and prioritizing what matters to us jointly. And there I say, what matters also has to be risk-based as well. So we are not going to be hopefully chasing every single non-strategic technical breach of law, but really focusing on those that actually create risks and harms for people, but also are perhaps instructive for everybody else.
All right.
So, there is clear progress, but I also was a little bit, unhappy or sad after that first panel where I hear this depressive state of nothing works, everybody's to blame. And I would actually put this potentially provocative point of view out there. I have heard enforcement in this cooperation consistency procedure is hard. True. Being an NGO is hard. Being an individual is hard. Frankly, being a company, and I'll tell you, that's hard as well. So what do we need to do as data protection community? And here I mean both companies and DPAs, not to get into that stage where we have to keep enforcing all the time. Enforcement is costly, it's the last resort, it's complicated, it's difficult for everybody. So we need to make sure that we actually do everything in our power not to get there. Prevention is 10 times better than reaction. Those of you who are data protection officers, right? How much do you care about security breaches? Gosh, you hope they never happen. You do whatever you can to avoid a security breach. Because when that happens, everything else goes down the drain, right? You cannot do your job. You're reacting, you're firefighting. And so my message would be, please, and you know that CIPL has done lots of thinking about this. There's been a shift and paradigm shift as to what the role of DPA is. I would say the role of DPA is not to enforce the law. The role of DPA is to ensure effective compliance, good protection and market behaviors in the EU or the country. And so how do we achieve that? Happy to talk about that. I don't think it's only through enforcement fines and so on. So for me, one-stop shop is not the way to get to highest fine.
Don't convince me.
I stop now.
Hey, I can't be convinced of any viewpoint. That's why I'm the moderator. I'm an empty platform of good ideas, but thank you. And I do share with you one understanding that the topic of enforcement has its limits. Those who are fully satisfied with thinking about enforcement only should start considering their spiritual life a little bit more closely. Yeah? Yeah, it's like a household. It's not only enforcing, it's enjoying, it's embracing the new, embracing the others. We talk about that tonight, I hope. But I'm curious about your intervention today. So the Access Now intervention in the former panel was about the individual. So what should we take away from you?
Thank you. Sorry, can you hear me?
We want to hear Access Now and Estelle.
Okay, I guess, yeah. Thank you. So, again, not surprisingly, I'm going to be talking from a data subject perspective, a person perspective, and obviously enforcement is not the only answer to make sure that a legislation functions, but you don't have good enforcement without good cooperation. Everything goes together, and also, sadly, we're just in a situation where in the status of data protection and privacy and fundamental rights in general, that if you don't have strong enforcement model, you do have a risk of having certain players in the market that don't play by the rules, which is not just to the detriment of the protection of those rights, but also of players who do play by those rules and invest a lot of time and money to make sure that they're compliant with legislation adopted. So enforcement in that sense is critical, or at least the fear of enforcement in most cases. So from a data subject perspective, a person perspective, the one-stop shop was supposed to be an important asset, which we don't necessarily remember because a lot of the time now the focus is that the one-stop shop leads to the decision of where the lead supervisory authority is, and it's coming from usually where the main establishment of a controller who usually have a complaint against is based. So it gives a lot of discretion to already the potential infringer to pick the jurisdiction, but we were supposed to also have a model that benefits people in order to ensure that their complaints gets to the right place, that there is this cooperation between the DPA representing them and the DPA that is the point of contact of the controller. And ensuring that we have a true one-stop shop for both sides is really important. I think there are efforts in this direction, but we're still, I think, missing a little bit of this explanation and understanding of how it functions and how it should function in terms of information back and the role that the data subject have in their own complaint in those cases. And that's where we see several elephants actually in the functioning of the one-stop shop, which is not its design, so it doesn't have to do with the way the legislation is drafted, but more how it's been implemented in practice. The first elephant is the fact that despite a lot of the effort that the EDPB as an entity and EDPB as the collective of the DPAs are putting in order to agree on this cooperation and try to agree on a single point of view for this harmonized enforcement and understanding, we see it happening, but there are still members of the EDPB that refuse to apply this guidance and then in draft decision or in statement decide to take a different position. So obviously it's complicated when you have a body made of independent authority that are entitled to their views, but if you create a system whereby cooperation is supposed to be existing in order to have a harmonized enforcement, if you have a single DPA that disagree with that, that means this is your weak link in your harmonized enforcement. And if your weak link happens to be also the lead authority for major cross-border cases, it means that your system may be in great danger no matter how much efforts you're trying to put, which brings the second elephant in the room. We all are aware of this, and who can fix that? It's not the DPAs themselves, it really requires the Commission to act. It's not, it's not a solution to just be, okay, the legislation doesn't work, let's redraft the legislation. The problem here is not with the legislation. We can just, it's maybe the sickness of Brussels. Each time something goes wrong, you make a new law, but you don't think how it's going to be applied. It's thinking what is going on with the application and how can I ensure, as Commission, as ensuring the enforcement of the law, that the level of clarity and certainty is given to the actor in charge of the enforcement, that they have the tools, the power, and then the resources to do that, but also the clarity, making sure that you don't have a single member that can make the whole system fail, which leads to the last elephant in the room as well, which is the resources. The resources come from the member state, and obviously all the member states approved the GDPR, except Austria, who actually wanted something stronger, but that was more a positive than a negative message at the time. They need to be given more resources to all the DPAs. I mean, I know we keep thinking of like, okay, so 2018 to speak about resources for DPA, their budget have increased. Yeah, they have increased, but their job have also increased, and it's really insufficient, the type of resource they have right now to be able to do their job. It's good to hear that as part of solution, they're becoming innovative on thinking we have to fit like quick cases, fast cases, but as data subject, we have a right to all of our cases to be looked into. It's important to have strategic cases, but they have to take those decisions because they don't have the resources to deal with every single cases. And that's not a failure of the law. That's a failure of not putting the tool by other actors to make sure that the actors who are in charge of it can success.
Okay. You saw many elephants. I tried to get them all out. I thought the EDPB was the elephant, but you identified many others. So this is what metaphors can do. Everybody can use them in their own thinking in different ways. But okay, EDPB is then the elephant now. So things don't always go smooth. There might be conflicts, and there might be urgencies. Yeah. So again, Florence, because you're smiling. Is the EDPB capable of dealing with conflicts and urgencies? Is it, or should more be made possible on behalf of the EDPB? Because should the elephant be fed and optimized, or should we keep it there?
Yes,
I'm not good in this elephant metaphor.
Too many elephants.
Too many metaphors.
Perhaps.
Yeah, I think it's a good question, Paul. And in fact, we are absolutely convinced that we need to decentralize those urgency or dispute resolution procedure, and that we need definitely to use them more. In fact, here as well, it's something totally new and that does not exist anywhere else. And so it's true that it's not necessarily easy to use them because of the very, very short timeline. And that's why it's really our responsibility to work on, to trigger the procedure when they are really necessary and when we have prepared the case as much as possible to allow the EDPB to be in a position to take a decision. But once we are ready, we really need to use it. And using this tool doesn't mean that cooperation failed, that it's a failure of cooperation or that it's not working. It's just a way to find a solution that is swift, made quickly, and shows that we are, in fact, well coordinated and that we can act when really it's urgent and necessary. And just to give you an example, we took yesterday at the EDPB a new Article 65 binding decision. It's a CNIL file, and it's good. We don't have any problem with that. We got an objection on one of our files, and it went well. It went faster because it was the third one. So we start to have now some experience on the way we trigger Article 65 and the way we are managing those Article 65, so the dispute resolution procedure at EDPB. So practicing is very important and help a lot. And we as EDPB should facilitate their use. Same for Article 62 and joint investigation. I mean, we really need to facilitate the use of all instruments provided in the GDPR and make or maintain a process that is flexible and enough agile. We also see the EDPB as a kind of cooperation facilitator, so to prepare, to ease the formal one-stop shop procedure, And in that sense, we have already started to develop a kind of a DPA enforcement cooperation toolkit by issuing many internal guidelines and procedure. So it's not totally done yet. We are not finished, but we have already done a lot in order to ease those procedures. And as Gwendal said, linked to the Vienna Declaration, we need also to prioritize, for sure. But it's not only about just identifying strategic cases, why not based on the risk-based approach, but it's also to make action plan on each of those strategic cases and to agree on a fixed timeline in order to solve them. So to have, something quite complete also in the term, as Gwendal said, to put in place a task force, action plan, I mean, to really to be well organized about the way we will deal with those strategic cases. Also, we need to foster a collaboration on minor case. I already talked about that, to see how we can mutualize our resources for this kind of cases. And last but not least, and I agree with Estelle, the Commission has also a role to play, for sure. We cannot solve everything. And so we know that there are some procedural obstacles that still need to be further harmonized at EU level, and it's where the Commission can be really useful, because it's the only one that can do something. So in conclusion, we think that the balance between EDPB and the national DPA, what we do at the one-stop shop, is very important, and it's quite well done thought in the GDPR as it is. We cannot imagine that you have thousands of complaints dealt by the EDPB. I mean, it doesn't make sense. So for sure, we need to maintain this one-stop shop, multilateral cooperation to deal with the complaints. And as Gwendal said, when we have a problem, when it's stuck, we move to the EDPB. And we still need, of course, to make the system working more and better. So in conclusion, what we can say is that we are not necessarily totally satisfied about the system, the way it is working today, but we are really for sure convinced that we can really do better and make it working better.
All right. Practice makes perfect. Yeah, that's it. And the Commission is the elephant. Huh? Yeah. So this is I keep that, please, for later on. What then could the Commission do? But perhaps Gwendal can react to Florence or explain us, because Didier Reinders was making us believe that the Commission shouldn't do anything. But I'm hearing advocacies in favor of more Commission intervention, so more Brussels.
Well, in any case, what we're doing and what we're focusing on at EDPB now is the problems we have right now in front of us, and there's a need to enforce on those cases. So we're trying to optimize the way we work together to enforce these cases. And this is why there is these initiatives I talked about before, because the objective is what? If authorities work closely together on the investigations, on the complaints handling, and so on and so forth, it's more likely that they will have a consensus. If they have a consensus, there's no need to have reasoned objections, relevant and reasoned objections. But in some cases, it happens, okay? And then they still need to work together to try to resolve those objections. And when it's not the case, you go to Article 65, where you have an EDPB decision to resolve the dispute. The challenge for the EDPB is that, and this is what is really unique, I think, in the digital regulation landscape, is that these decisions are, by definition, extremely complex, and they need to be taken in very short time frames. Why are they so complex? Because we're talking about cases on which authorities throughout the EU have been investigating for 1 or 2 years, sometimes more, and they haven't found an agreement, and this goes to EDPB, and EDPB has to prepare this Article 65 decision in a month. So how do you do this? This is the challenge. I have, we talked about the number of Article 65 decisions we're working on. When we have multiple ones at the EDPB level, it paralyzes also the rest of our activity. So it's also an issue of resources. We need enough resources to be able to deal with these cases, because they will happen, and they're in general on complex legal situations, or potentially on high fines. And we need to meet very high quality standards because these cases are going to be challenged. There's more and more litigation. One example, we have a case right now in front of the Court of Justice of the EU following an Article 65 decision by EDPB on a big tech company that led to a fine that was 225 million euros. This case is being challenged. So we need to make sure that the Article 65 decision is sound. And then when there is litigation, we have to make sure that the Article 65 decision is robust and stands, basically. And this is what we're doing at the European level. And we're doing it with a very small secretariat. So this is one of the challenges we have before us right now, because enforcement is ramping up at national level, so it needs more intervention. But not everything is about dispute resolution, because as I said, in many cases, authorities agree, and we need to make sure that in the maximum number of cases, they will agree by construction. Yeah. And this is why we work so much, and we have all these initiatives on helping authorities to cooperate better together. Because when they cooperate, they have consensus. And in some residual cases, you will still need the dispute resolution, but it's going to be swifter with questions that are more targeted, and that can be handled with the limited given timeframes that I mentioned before.
Yeah, thank you. Bojana, I saw you nodding, so I think this is also your idea, avoiding a deliberation from scratch at the end by preparing the procedure better.
Exactly, and I think that's the boards. You know, board is supposed to have that leadership because it's difficult. You know, these are 27 DPAs who got day jobs and they've got to do this other job. I mean, really, I have to defend DPAs. The GDPR has given them very bad set of cards. You know, you've got lots, no aces, no dames, I mean, really hard. It's hard design, this. And so I think we need some leadership, and EDPB has to do that leadership with staff, with resources, with permanent, somebody talked about DRFC, the Regulatory Cooperation Forum in UK. That has got a CEO now, right? They've got staff, they've got money, they don't just talking, they're actually doing things. Well, so, you know, we need the board to do that. Several ideas that we have put forward. First of all, relevant reasoned objections, right? Like that can't be just the way for everybody to complain. We want that to be just in cases where there's a real serious concern, and to end in a way where there is a self-restraint by the supervisory authority, and that's the way that's what the board should be promoting. Maybe a presumption that the lead supervisory authority approach is actually to be accepted, unless there are really serious, compelling reasons against so. So trusting that system, but then also asking the LSA to share, cooperate, prepare information so that we don't get to that space. Remember BCR, Florence, we have built BCR from scratch. That was not in the directive. Companies and smart DPAs invented this tool. And we can invent tools like that. And the procedure of BCR is one is the lead DPA, and then the two are kind of secondees. They're the one for checking. Well, why don't we have a similar procedure where in some cases we have got one lead supervisory authorities and two perhaps working together and reporting that if there is a dispute, then it's easier to deal with, right? Like a two-tier system. Special EDPB subcommittees that have got expertise that is dedicated to this consistency and one-stop shop, but also special expertise on special topics as well, because there's going to be more and more, and not just through pool of experts, but actually experts who are embedded in the EDPB. There was a lot of discussion, you've heard this today, by, you know, how can we create common procedure? And at the beginning of this discussion, there was talk about we can't have, this is all national procedure, but you can have a common procedure in matters that are matters of European law. Well, EDPB consistency procedure is a matter of European law, so there could be some common procedure. And let me give, and I heard very well, Estelle, and from earlier panels, there are issues around right to be heard and transparency vis-a-vis individuals, and I totally agree that has to be fixed. But there are other things vis-a-vis companies. So let me tell you what the world looks like there from those companies who are participating in this procedure. there is zero consultation on any of this stuff, and you actually don't hear from companies, but yet they actually have got interest in one-stop shop. Can I tell you, there are a number of European companies who've told me, I don't want to have a single establishment or lead DPA because it's a mess, so I'm going to deal with 27 my old-fashioned own way. That's not what we want. Apologies, that's what I've heard. Second, access to all the evidence to be considered in the case. That must be done. Confidentiality of proceedings. We can't have talkings about proceedings while it's going on. That's not how anything works in this world. Obviously, common timescales, we talked about that, but right to be heard further in the process, particularly in the Article 65 proceedings, is really important to make representation to the board. That doesn't exist today. Again, I will remind you, when the BCR were actually upgraded from the old-fashioned to what we have now, all these joint opinions, I was actually summoned as one of the companies who pioneered BCR in front of Article 29. Terrifying procedure to actually talk about this, how this works, why do we think it should be like that, instead of going with one by one. As a basis, as a result of that, we have this now common BCR procedure. So we just have to remember our institutional muscles, have to remember how we did this pre-GDPR, right? There was that kind of ability to be heard, ability to make representations in the process as well. Relevant reasoned objections. If you are a company in the one-stop shop, you don't know anything about this. Nobody tells you who has made what, how they have made this, right? And then making formal representation before action is taken. So these are some of the things that I kind of feel really need to be done as well in terms of procedural aspects, and I think board should be driving that.
Okay. Estelle, I can never guess your thoughts, so again, please share.
Thanks. Okay, so we've been discussing a lot cooperation and what it means, which first maybe we should also say that it's not specifically an issue of the GDPR. There's many EU legislation that just assume and put forward cooperation between different entities and just leave it to them to figure it out. And this is really not easy to do, and also something that is actually not really happening in many other sectors, like the law enforcement sector or others. So the fact that the EDPB at least had a partial experience of the Working Party 29 is quite good, and there's some learnings from that we can continue carry on, that maybe in building the EDPB got put on the back burner or forgotten a little bit, like joint investigation, which were really important and really key to advancing case of EU-wide interest. And we are seeing EDPB now taking up more proposals like that, and they would be really interesting, just echoing what my colleagues say on the other issue, is that in many cases that are brought, that we bring in terms of data protection, they're true for us as an individual, but they would be true for each of you individually, because often they have to do with a systemic data protection issue from different actors. And so a lot of the cases, even if they may be national or limited to one jurisdiction or under the control of one jurisdiction, they have an interest EU-wide. And maybe trying to really see within the tools under the GDPR, isn't there a better way than the one that is right now, that maybe is a bit slower than hoped? Because one of the objectives of the GDPR was to make sure that, people don't really feel like they have a right to remedy on data protection violation, because going to court is expensive, is lengthy, and you don't really know what to expect. So the one-stop shop was supposed to fix that, and we're not really there yet. And I really, I'm sorry, Bojana, I'm going to contradict with one point here, but
go ahead.
You say company don't want to use the one-stop shop, but from our perspective, what we're seeing is that a small number of really large companies are actually hiding behind the one-stop shop, where it's not even sure in the first place there should be under that model. I would question if a lot of the companies that have their main establishment in the Netherlands, in Luxembourg, and Ireland actually are the single controller. At best, they would be joint controller. Like, I don't know how we can consider that Facebook Europe 100% take the decision on how the processing of data is happening on the platform without Facebook California. What does it mean for the system? What does it mean for the other DPA and how they could intervene? And what does it mean for maybe bigger coordination and enforcement there? And maybe now a more practical point, we've heard the huge improvement that has happened, though, from Working Party 29 and the limited interaction that DPA had, and the increased number under EDPB, which is obviously visible. But maybe we need to reach to a point where it's not about rethinking new model or thinking new authority, but really empowering the EDPB, but empowering the EDPB by giving a greater voice of all the national authorities within the EDPB, by perhaps maybe have a permanent member of each authority or group that are always physically at the EDPB, working on those cross-border cases, working on those guidelines on a more continuous basis, which requires, again, investment from everyone. But if we're investing in doing a legislation for 10 years, we should also invest in enforcing it for 30 to 40 years. And just putting the resources out there to make sure that this culture of cooperation is there, and hopefully slowly enforcement will no longer be an issue because things will be clear and authority will work better together. But a lot of the learnings that we have already, a lot of the tools are here to be used, but it's a little bit scary to use them because they're new and to challenge each other. I understand that obviously if you challenge your main establishment, you're challenging your colleagues, but it doesn't mean you disagree with them, and some of them are daring disagreeing with you, so I would just dare you to disagree back with their findings.
Wow. Now we all want to know what all these speakers think about each other's intervention. But then we would not give Zuboff the forum that she deserves. We are under certain time constraints, and many things have been raised. So there has been a plea for building a culture that guarantees that it's not only about conflicts and not understanding each other, but that you avoid actually a litigation kind of model. But on the other hand, some disagreement can never be avoided, and those who dream about a life without disagreement just bluntly err. Disagreement is part of life. And so that was one stream of thoughts, but then Bojana added a kind of lawyer's view on this. So the EDPB and the DPAs are taking legally binding decisions, so we're not all friends. And lawyers are trained to litigate against DPAs, and they will get better. And so the DPAs will have to be better, and the same for the EDPB. It will, within short limits of time, have to reach consensus, but be able to defend that consensus before the Court of Justice. So trust building and law, sometimes I see that as not so easily coexisting. And then there are, of course, very practical suggestions to improve and to think differently this unique experience. And between the national and the supranational, we have the transnational. So I really like the idea of sharing offices. I like the idea of weekly meetings so that you work for your local boss, DPA, 4 days a week, but on Fridays. What is this? What is the day of the weekly meetings? Okay.
It's Monday. We start with that.
It's Monday. Wow. Okay. I had another image about these elephants because there is an Islam proverb that you always should trust Allah and everything will end up good. But at night you have to tie up your camel because if not you lose it. So I would bring in this beautiful image to position enforcement and trust in the right way, at least in a spiritual way. But don't forget at night that your animal is out there and could be stolen or something. So I finally had my take on that elephant. I'm very proud now. Now we have, before going to you, let's do a complete an empty table exercise. So very short round. If we could have done it again, if the proximity tribe wasn't there, or for instance, or the pro-Europe tribe wasn't there, how would you do it? Would there be another EDPB? You don't have to answer because it could bring you into problems. But if you have broader and wilder fantasies, even breaking up the GDPR, let's assume that that is possible. Gwendal?
No, I think what we're trying to say, and is what we heard also today, is that everyone is expecting a lot from the DPAs and from the EDPB. We have a lot of ideas, but we need resources to be able to do that. There's been comparisons with other legal fields. Just as a matter of comparison, and I won't give you the figures of all the other legal fields, but the EDPB Secretariat is more or less 30 people, and there's 19 officials, so it's not very big if you compare it to the other fields that we have been talking about today. So for sure, we need more resources to be able to foster this cooperation, to do it by design, to avoid the conflicts, to resolve the conflicts quickly, to have common standards for enforcement, to make sure that enforcement is done in the same way across the EU, to improve our IT tools. So to be more efficient, to be faster, to be up to quality that is expected from us, and we're fully aware of this. We do our best, but we need more resources to do even better. So I think this would be my conclusion. We're working under the current model. This is the case, and our priority is really to continue to improve what we have been doing in the last 4 years, so that the authorities can continue to be more efficient and meet the expectations of the citizens, meet the expectations of the NGOs, meet the expectations of the businesses, meet the expectations of the politicians, to make sure that this is working perfectly well on all the cases. And keep in mind that we've delivered already quite a lot in a limited period of time, but a lot is still expected from us, and we're fully aware of this.
Want to skip you?
No, I don't escape.
She's got right to be heard.
So you speak about an ideal world. So in ideal world, there is in fact full compliance, no complaints, no need to cooperate. Yeah. Everything is going fine. No, we hear about a lot of critiques about the current model and some ideas of centralization, for example, or to use as a model the competition law and environment. And we really think that we have to be careful not to mix everything. Here we are protecting a fundamental right, and we are not necessarily protecting the market. So we don't have necessarily the same goal. We protect people, and in the field also of competition, by the way, we have reintegrated the national authorities in the centralized model. But so we think that we have to be really cautious about solutions which would result also in a more distant interlocutors for individuals, but also for companies. I mean, Didier Renders talked about proximity. That was one of the cornerstone of the GDPR, and it's very important. So that's why we think that DPA really should remain competent and in charge of dealing with individuals' complaints, and also be in contact with the company in order to help them and to accompany them in their compliance. So if the question is, do we have to reopen the GDPR? We don't think that it's a good idea. We think that it's too early. We need to first to improve. We still have some room to improve the system, and also we have, as Didier Renders said, we have to be very cautious about the Pandora box. Last but not least, it's my conclusion. We should not forget the rest of the world. Yesterday, I was intervening in a panel with Taiwanese authorities, and they say how much they consider GDPR as a model, and also Europe as a privacy leader. And it's the case with the other countries that are currently drafting their legislation and that are using GDPR as a model. And so we collectively here, I mean, EU civil society, EU business representative, EU companies, EU DPOs, EU DPAs, we are all actors of this implementation of the GDPR, and we are all responsible, in fact, to make it work. And so we see really this discussion not to kill the GDPR, but on the contrary, to improve it and to make it better.
Right.
Okay, my wish list, short of revamping everything, but would be, and this could be done, more engagement and transparency from the board vis-a-vis business community, but everybody else. You know, what happened to those core regulatory mechanisms? What happened to code certifications? What happened to businesses being consulted, having a point of view? We don't even know subgroups exist. who is in subgroups, what are the task force is doing. And I appreciate it really takes a lot of time and energy to engage, but the more we engage, the less we will have the enforcement need. So the more we are able to understand and talk to each other, the better it's going to be later. So engagement and transparency are really going to be super important for me. Now, I might dream, perhaps, maybe EDPS takes a bigger role in the future. Maybe they take bigger role with the EDPB together, because I do not see this model working in what we are going to see with the AI Act and DMA and Data Act. How are we going to slot all of this complexity into even bigger complexity? Because we'll have to now work with other regulators. So, and somebody said to me, whose phone do I pick up here? National, EDPB, EDPS, competition, AI, sectoral, it's going to be complicated. So we have to get our house in order before we start claiming that we can do better things like DRCF or something else at European level. So I don't know. I think there may be more powers given to the board and EDPS to take this forward without, of course, taking the competence from the national authorities. So that's going to be the dilemma for Europe.
Yeah, all right.
Thank you. So,
and agility. I've forgotten that.
So I think weirdly the first on my wish list is also to clarify what should not happen, and I would not advise of reopening the GDPR or trying to modify the GDPR. Not just, I don't think not at this stage, but I'm not even sure like in few years' time, in the sense the issues we're discussing at every level, I think where we can find an agreement, and obviously there are different perspectives, but everyone involved in enforcement or incorporation in their own perspective, what we've been putting out there as really the hurdle for making it work as perfectly as everyone would want is the discrepancies between the national procedure and practices with the GDPR and what the law was supposed to deliver, and lack of resources, and some maybe individual disagreement of few members that is more a political issue. But if the issue is about national law impeding the protection of EU rights and the application of EU law, this is really meaning that one of the elements of GDPR that was supposed to be, we're not going to talk about applicable law because it's going to be EU law that is applicable and that should be clear. Okay, that's maybe one point that wasn't clear and where we need the Commission to help and intervene, because if every level is able to recognize that this is something that hurdles us for the right to be heard in different places, or our complaints to be lodged and handled, DPS to be able to work together even when they want to but have to follow their national procedure and are stuck there, let's fix that. You don't need to change the GDPR to change that. And if you change the GDPR, you're changing EU law, you're not changing the national procedure. So you're going to be stuck with a new model with the same problem. I don't think completely centralizing an enforcement model is advisable for data protection. It's a fundamental right. People need to still have a link. But I would agree that there could be and there should be a bigger role for EDPB and for joint cooperation of all the DPAs within the EDPB for many of the cases of data protection that are not just actually individual infringement or individual rights question, but societal problem.
All right. Promise me that you sprint to the other avenue because we're late and Olivier is very angry now. But I hear a lot of things. I hear searching. I hear an effort to make things work and to make new things work, which is hard. So, but I hear optimism that is so far justified. But then I also hear calls for a more participatory management structure, opening up not only to the colleagues but also to the field out there. And I do hear also a plea for useful clarifications by the Commission. So it's perhaps not much, but for me it's a lot to take, and it's subtle. So you two, thank you for having been here, and thank you for this.